afternoon. I keep saying morning. I guess I don't want this day to end, so I'm trying to make it a long morning. Welcome. We're glad that everyone could come today. We enjoy having a full house. Maybe that way I won't get a cricket on it. I'm Dawn Barnes. I'm with Cooperative Extension. This is put on by the FACT group, and we are the Floyd Aging Conversation Team. Cooperative Extension is part of that. Agency on Aging is part of that. Janet Brennan is part of our team. Social Services is part of that. And Linda, thank you. My peripheral vision is gone. John Vest is with Cooperative Extension. So we are part of the team just trying to bring some educational opportunities into the community. We have an evaluation at the end of the day. One of the questions is, what are some other things you would like to see? And we hope you'll take time to fill out the whole evaluation, but especially that particular question. We're not going to spend a lot of time up here at the moment because these are the important people, but some quick housekeeping. If you have a cell phone, please take it out and make sure it's on silent at the moment. Restrooms are out this door, down the hallway on your right. Snacks and some bottled water is in the back. If you need to get up at any point during these seats are not the most comfortable, so I'm sure if someone needs to stand up in the back or whatever and stretch, please do so. Just to let you know so you won't panic, the cameras in the back, we're going to be fortunate that Citizens is going to be able to take this and also share it, so there will be more people in the community that will be able to gain the knowledge that we have for the wealth of the knowledge that we have here today. So what we're going to begin with, I'm just going to go ahead and do the introduction of both. We'll switch the two speakers about 55 minutes. And again, if you need to get up at any point. But we are very fortunate to have with us Ann Hart-Brinkman.
Hello.
Who will be starting us off today, and then Ann McGree-Green. So this is the Ann show today. Ladies, thank you. It's all yours.
All right. Well, good afternoon, everyone. I guess the mic is picking me up, but I'll try to project. Please, at any time during the presentation, if you can't hear, just throw your hand up and I'll know I need to get closer to the mic or talk a little louder for you. I'm very appreciative of the opportunity to be here today. I was, contacted through my work with the Department of Social Services. I represent the Floyd County Department of Social Services. I also represent Montgomery County Department of Social Services and have been representing DSS agencies since 2007. And at this point in my practice, that is pretty much all that I do. I used to have a general practice where I did a sort of broader array of legal work, but my passion is with the Department of Social Services. Because of that, my presentation is a bit focused today on a couple issues. So I'm very happy to have Ann Green here as well, because she is one of the most respected elder law and estate planning lawyers in our region. And I'm often referring people to her. And so, or contacting her when I have a complex issue. So I always appreciate her insight and guidance. And so she will be able to kind of pick up on a broader array of topics for everyone to consider as you're thinking about your future or future of a family member or a friend that you're trying to help. With DSS work, we kind of unfortunately see the most dire situations that are a result of folks not having a plan in place or any kind of document to help allow someone to assist them. And those cases can be very serious and very sad when they reach that point. So hopefully, that will not be something that any of you encounter, but I think being aware of some of these issues, could also help you look out for those in the community that you see could maybe use some help. And that's something that our department always wants to be able to assist with. My presentation today is going to focus on powers of attorney and then guardianships and conservatorships and the difference between those. It's actually one of the most common questions I get, even from social service workers contacting me to say, hey, there's a power of attorney. Does this person, here's what's going on. Does this person still need a guardian, or is the power of attorney, is this good enough? And what I will say is that, today I'm providing sort of broad information. It's really important to understand that every case has to be looked at as case by case, because there could be the same question in two cases and the answer is going to be different. So please understand that, this presentation itself is not direct legal advice. It's just information, and it does not substitute for communicating with legal counsel if you have legal questions. So I probably should have already done this. I have some handouts here. Okay. And I was surprised at the turnout. So if you came with, if you're a couple, if you could share just to make sure that everybody gets a copy of those. So I wanted to start by going through what a power of attorney is, what a conservatorship is, and what a guardianship is, as those are defined by the Code of Virginia. And some of you may be familiar with powers of attorney. Powers of attorney can be very different. There are a number of code sections dedicated to powers of attorney. So very generally, a power of attorney is, and this is on the one-page outline, a writing or other record that grants authority to an agent to act in place of the principal, whether or not the term power of attorney is used. So the code is sort of indicating it doesn't have to say power of attorney. Obviously, lawyers like things to be very clear, and so we would prefer if there is something intended as a power of attorney, it's clearly stated as that, and has the appropriate references to the code. Within that definition is the definition of an agent, and that is a person who is granted authority to act for a principal under a power of attorney, whether denominated an agent, attorney in fact, or otherwise. And then the principal is an individual who grants authority to an agent in a power of attorney. So that would be, if you are wanting to have a power of attorney for a spouse or a child to act on your behalf, you are the principal, they are your agent. A conservator is a person who is appointed by the court, and that person is responsible for managing the estate and financial affairs of an incapacitated person. And I will say that word incapacitated person is also defined by the code. I did not include that here, but it's important to understand that incapacitation would be determined by the court after a medical evaluation has indicated that the person is incapacitated. And where the context plainly indicates, it includes a limited conservator or temporary conservator. And again, that would have to be included specifically in the court order. A guardian is a person appointed by the court who has the powers and duties that are set out under those code sections, and who are responsible for the personal affairs of an incapacitated person, including making decisions for the person's support, care, health, safety, habilitation, education, therapeutic treatment, and if not inconsistent with an order of involuntary admission, residence. And again, where the context of that order would plainly indicate, the term would include a limited guardianship or a temporary guardian. So, three different legal mechanisms to allow for someone to make decisions for you, manage property and affairs. There are some similarities that are important and some differences. So I've included those on the outline, and I want to go through those. A guardian, a conservator, or an agent who is acting under a power of attorney is a fiduciary. And so a fiduciary is someone who's required to care for someone's interest and property for that person's benefit with care and loyalty and without self-dealing. There's lots of other definitions of a fiduciary, but essentially a fiduciary is responsible for taking care of the individual's best interest when it comes to their property. A guardian, conservator, or agent have the ability to act in place of a principal or incapacitated person subject to any limitations either in the power of attorney document or the court order. And so that's important too. And this is part of why I was saying how each case has to be determined case by case. If I have a social worker call me and say, hey, they've got a power of attorney, is this good enough? And I say, I need the power of attorney. I need to look at it because they can be limited. You could have a power of attorney that, say you want to purchase some property and you're going to be out of town. You could do a specific power of attorney for, say your spouse to sign your name on all of the legal documents at closing. And that would be very limited, likely to that day and that piece of property. So there can be all kinds of limitations within a power of attorney. It is important to note, though, that all powers of attorney in Virginia are deemed to be durable powers of attorney unless they say otherwise. And a durable power of attorney means that they would continue after an individual has been determined incapacitated. A guardianship order, conservatorship order, or power of attorney can name another individual as either a standby guardian or conservator or a successor agent in the event that an initial agent is unwilling or unable to serve. So you have the ability to kind of provide for some backup there. The differences are perhaps more important than the similarities, and those include several notable differences. A power of attorney requires only a signature before a notary. I think most lawyers, kind of as a best practice, do like to have witnesses, but it's not required by the code. Whereas a guardianship or conservatorship require a court filing, proof of incapacitation by a medical professional, and an investigation and written report to the court by a guardian ad litem who is a lawyer who has been appointed to represent the individual's best interest before a court order could be entered. A power of attorney does not restrict the principal's right to act, except under some terms in a durable power of attorney. And a guardian and conservatorship does restrict the incapacitated person's right to act, subject to the terms of the court order. This, to me, is the most important consideration for the department when we are looking at whether or not an adult who has been perhaps exploited or is in a neglectful situation, even if it's self-neglect, what we're looking at is a power of attorney going to actually protect that person? And the way that might not be the case is if you have someone who has been subject of exploitation, where they have, picked up on some of these scams, or someone who perhaps is still very active in the community, likes to go to the bank, is maybe would be vulnerable to, co-signing a loan for an extraordinary amount of money, something like that. Because the main thing is that with a power of attorney, the individual can still act. The agent can act as though they are the principal, but the principal can still act. And so that's where we're kind of evaluating whether or not we need to move on to guardianship to protect that person and their property if they're not able to act in a way that is, protective of themselves. And so, but there are times that a power of attorney is just fine. I have a situation where, maybe a child calls and said, they're concerned about their parent. Maybe there needs to be a guardianship, but they have power of attorney. And maybe the, parent is in a assisted living or a nursing facility. And there's really not any concern about exploitation. There's not any concern that they're going to be going out and entering into contracts on their own or anything like that. In those situations, it may be appropriate to continue under the power of attorney and not move on to a guardian or conservator. And again, with a guardian and conservator, it is possible to have that very limited. You can have, a guardian that is restricted in their ability to determine someone's residence. You could have a conservatorship that is restricted in that they are not authorized to sell property. So there are ways to craft a guardianship or conservatorship that is not as broad as a full guardianship conservatorship, where essentially the individual doesn't have really any say or any rights. With that said, it is a requirement of every guardian, and it has to be in every single court order in 14-point font, that a guardian will take into consideration the incapacitated person's wishes, and to the extent that they can, honor those. So the law does recognize that even if an individual is determined legally incapacitated, that they still have the ability to say what it is that they want, to communicate with their guardian, and the guardian is under an obligation to take those things into consideration. The third difference I wanted to point out is that a power of attorney generally has no oversight. You can have a power of attorney that and I don't recommend this, but you can have one printed off, from some online website and signed before a notary. And that's it. That person can act. That is somewhere, unfortunately, that we do sometimes see exploitation in the adult protective services realm. Whereas a guardian is required to file reports annually with the Department of Social Services. And if the Department of Social Services is not receiving those within 90 days from the date they're due, we're required to notify the circuit court that report has not been filed. So there is court oversight and some oversight by the Department of Social Services. Similarly, a conservator is required to file an accounting within 4 months from qualifying, and then annually thereafter. So they are required to account for all of the funds. So there is that extra protection of oversight. I think Anne will likely talk about some of this when she talks about some of the planning that you want to do, conversations that you want to have with family. But it is important to really, think about who it is that you are authorizing as your agent, and talk with that person and make sure there is some understanding of, what it is that you want, and that it's somebody that you trust, that it's not somebody that, has had a, problem with stealing in the past, or has had, a substance abuse issue that has led them to poor judgment. It's really important because with that power of attorney, like I said, there is really not any oversight, and they're completely authorized, to act on your behalf. We have had cases where criminal charges have been brought against individuals who had a power of attorney, but are clearly exploiting the individual, who are, using the funds for themselves. We've had one recently where there was like a, $1,000 salon charge in another state, clear the man hadn't been there, things like that happen. So there are ways to kind of take action after the fact. But we really want to make sure that we're doing as much as we can up front, to protect ourselves and those that we love. So there are some connections with a power of attorney and guardianships, conservatorships, and a power of attorney can nominate an individual. So within a power of attorney that you draft, you could nominate someone that you wish to serve as your guardian or conservator should an action be filed for you to have a guardian conservator. It's important to understand that does not mean that is the person that the court will appoint. There is still a requirement that a guardian ad litem who is going to be representing, your best interests, do a full investigation and report. So it could be that at that point, the person you've nominated does not seem to be appropriate and the court may not appoint them, but you do have the ability to have your say, that is who you want through a power of attorney. And if a power of attorney is in place already, when the court appoints a guardian or conservator, the order appointing the guardian or conservator can limit, suspend, or revoke the power of attorney. But they don't have to. The order can be silent as to that, or it can specifically state that there is a power of attorney and that this order is not changing that power of attorney in any way. In that case, the agent under the power of attorney then is required to answer to both the guardian conservator and the principal under the power of attorney. So it could get a little complicated there. And for that reason, we generally do our orders, and again, we're dealing with a specific sort of set of circumstances, usually, abused, neglected, exploited individuals, but we normally are revoking powers of attorney in our court orders to make sure that there is one person that is, making those decisions. But that's not to say that it wouldn't be appropriate to handle in a different way. So there are a lot of options there. I wanted to touch on the guardian ad litem again. I've referenced that a few times. And so when there is a guardianship or conservatorship matter that's filed, a guardian ad litem is appointed. That's a lawyer who would be representing the alleged incapacitated person's best interest. They have a very special role. It is different than a lawyer. And there are times that a guardian ad litem will contact, the court and the other counsel to say, I think this person needs a court-appointed counsel because my recommendation is contrary to what they want. They don't want a guardian conservator. I'm going to recommend they have a guardian and conservator. They need a lawyer to assist them in, trying to defend against this. And the court will do that. In fact, I think, I was pregnant. It was probably 9 years ago. We had a jury trial on a guardianship conservatorship matter where we had that issue where a guardian ad litem was clear, in the recommendation that this woman needed a guardian conservator. She did not want one. And so the court appointed counsel and that counsel requested a jury trial. So we had a jury trial and she had both a guardian ad litem and court appointed counsel representing her. So that was kind of a unique situation, but that can happen. That individual, the guardian ad litem, is required to make a written report. They're required to talk to everyone who is identified in the petition. The petition has to include 3 adult relatives of the incapacitated person that gets notice of this proceeding, and to give a reason. If we can't find 3 adult relatives, we have to state why not, what we've done to look for a relative, because the law wants people to be involved, wants family to be able to weigh in to make sure that the guardianship conservatorship process itself is not exploitive, right? That it's not just someone coming in saying, I need to be mom's, guardian conservator because I need to make sure I, keep the farm or whatever. That it is, everyone has an opportunity that, anyone who is in that person's life, family members, has an opportunity to come before the court and express any concerns. And so the guardian ad litem will talk with those individuals, meet with the alleged incapacitated person, and make a written report to the court about what they're recommending. And that will recommend what the order should state in terms of if it should be limited, if it should include, if the individual should maintain voting rights, if there's driving concerns, what the finances are, those will all be listed out. And if there's any, sort of concerns, like in our cases with, ongoing contact with certain individuals who, have been in a position to exploit or abuse or neglect an individual. So those are kind of the basics. And I wanted to have an opportunity for you all to ask questions. And so I thought it might be good to take a few questions now, if you have any, because I'm sure there's going to be a lot of questions for Anne. So are there any questions at this point?
Typically, if there's a power of attorney in place,
Mm-hmm.
and someone has power, it couldn't be overturned if it's a reasonable person and things are normal. Like there's no typical abuse, neglect, thievery, or anything else. Is that correct?
So I think it would probably depend on why. My first question, if someone came to me and said, "Can we leave this power of attorney in place with this guardianship proceeding?" I would say, all right, what is it that you need out of a guardian conservatorship that's not being accomplished with this power of attorney? And if there is a concern that, the power of attorney is not sufficient to protect the individual's rights, but the agent under the power of attorney was acting appropriately and was interested in being the guardian or conservator, then that would probably be a better mechanism if there was some reason that it needed. Like I said before, if, say you've got somebody who's used to, being able to go to the bank, sign loans, that people come to them for money. They're known in the community to be very generous. So they're writing checks and, they're acting on their own. If that is happening, then perhaps a guardian conservatorship would be necessary in that case. And so what we would hope, if that came to us, is that the individual who's the agent under the power of attorney would be willing to be the guardian or conservator, because it does require a little bit more in terms of, documenting, and it has a bit more of a burden sort of legally. And so that would kind of be the way I would look at that situation. Does that answer your question?
Yes. Okay. And can you not, when you go to court, in a situation where there is a power of attorney, as discussed, that has not done anything wrong, but the principal is thwarting their efforts because of their incapacity. We've done this with trusts, and but I don't see there's a reason you couldn't do it with just a power of attorney. You go to court and say this person is incapacitated, but has a medical directive, has a power of attorney who's acting in their best interest. There's no need for a conservator. Now, I know that that's risky because there's no accountings. Because once you get the conservator in place, whoop over to the commissioner of accounts, there's accountings, it's going to be expensive, there's bonding and all this.
Yes.
And so if there's a good power of attorney there with no reason that they couldn't continue, that's an option, just to have the person determined. And we've done that in the past. The other thing I've seen the power of attorney stay in place for was a situation where the power of attorney specifically did not give power for real estate. And they had a disabled child, and we wanted to get the asset to the disabled child and also put the house in the name of the father. But we had no authority under the power of attorney to make gifts, one, but also two, to deal with real estate at all. So we went to court and said, Your Honor, could we do this? And so a limited, conservator for this purpose, and then it ends, and the power of attorney stayed in place because there was nothing else that needed to be done. So like you said, you can be crafted in a lot of different ways.
Exactly. And those kinds of examples sort of highlight why, it's kind of important to be thinking through all these issues, because you can craft your power of attorney for that specific situation. So to sort of like protect yourself from your own incapacity in the future, if you would prefer to stick with that power of attorney. And it is, there are, when you file, there are, costs associated with that. You have to go to court. A lot of people don't feel comfortable, going to court on their own. So their, family members may feel like they need to hire counsel. It is quite a bit more, sort of a multi-step process than a power of attorney.
Appoint your power of attorney, whereas the court will appoint a conservator.
That's right. Yeah.
Can you have a joint power of attorney?
Do you mean like co-agents? Mm-hmm. So you have two people who can act on your behalf? Is that what you mean? Mm-hmm. Yes, you can. Yep. And you can specify that. And like I said, that can either be co-agents or it can be sort of successor agents. So, if, my daughter, Mary Jane is not willing or able to serve, then I nominate and you put another agent in there. So you can have some backup there. Because, if you're executing a document like that, you don't know. It could be 10 years. You don't know what's going to be going on with the individuals you've appointed. And maybe in the interim, you haven't thought about updating those documents, which I'm sure is something else that Ann will touch on. It's really important to kind of do that periodically. Other questions?
All of those documents die with the person, like all of the duties that are.
Yes. The powers of attorney do. The guardianship or conservatorship, the guardianship often will specify about the ability to make arrangements for funeral if no one else has been identified as being responsible for that. And then for the conservatorship, they would work with the executor if they are not themselves the executor.
And to touch base on that, am I correct in one of which would be for your medical decisions and the other one would be financial?
Yes. And so there is, I think there's some, there's advanced medical directives and powers of attorney. Sometimes that the medical directive is sort of, those provisions are sort of incorporated. I've seen powers of attorney that sort of include that. And then there are also separate documents, and there's different reasons for doing it different ways. Yes.
So Anne, could you expand on the role of the conservator and the role and responsibilities, and especially with the reporting the information? But what I don't want to use the word consequences, I think repercussions, for failure to fulfill that responsibility in reporting as a conservator.
Yeah, so and I'll kind of back it up to the point of appointment and really what should be before the point of appointment. It should be before any filing actually even happens, is there's a discussion or should be a discussion by whomever is considering filing with the individual who is contemplated as a prospective conservator about, do you have any, have you filed for bankruptcy in the past? Do you have any crimes of, lying, cheating, or stealing? Do you have any problems with your credit? Because the law requires some sort of bond. Now, sometimes that could be an unsecured bond, but if there's property involved, and of course, we're dealing with folks that sometimes don't have property, but we've also dealt with people that have, it's sort of shocking that some people that have so much money, but still DSS is in a position to help them because they didn't have anything, arranged for them. And so when there are a lot of assets, sometimes there is a pretty significant bond. And basically the bond is, insurance. And you would work with an insurance company to post the bond, but it's insurance for you dutifully fulfilling the role of conservator, so that you could be responsible for that bond amount if you do not fulfill your role as a fiduciary. Now, there's kind of it probably varies jurisdiction to jurisdiction what happens when an accounting is not filed timely. Because there are commissioners of accounts that are lawyers who are appointed by the court to be responsible for maintaining those accounts. And I've seen differing levels in different jurisdictions of kind of being on top of those things. But generally what happens is they would notify the court, and there could be, then basically a show cause where you have to come before the court to demonstrate why you haven't been fulfilling your responsibility. And again, just to emphasize that technically the repercussions for any fiduciary, even under a power of attorney, not fulfilling that role, that is an actionable offense. A fiduciary who has violated their role as a fiduciary, that is considered a criminal offense. And of course, there could also be civil action. So it's pretty significant, assuming you have a commissioner that's on top of that. Other questions? Yeah.
Yeah, could you talk a little more about the difference between the power of attorney and the durable power of attorney? I often hear that that's really important for us to understand.
Yeah.
If we're healthy, if we're just aging, we need to think to the future a little bit.
Yeah.
you could talk about that.
Sure. Yeah. So the durable power of attorney, again, I want to emphasize under Virginia law, every power of attorney is considered to be a durable power of attorney unless it states otherwise. Now, despite that, you're still going to see durable power of attorney on a lot of these documents because, again, it's important. Lawyers want things to be very clear. And it's also important if you were to move to another state or something like that, that it's clear what was intended under Virginia law. And so the durable power of attorney would be a power of attorney that does not expire upon the individual's incapacity. And there can be different, really there's kind of, and I'm sure Ann will talk about this too, there's a lot that you can put into a power of attorney to specify what you mean, what would be the factors that would determine, incapacity under that. So the most important thing in, all of these documents is being very clear about what your intent is. But that's the difference between a power of attorney in Virginia is going to be a durable power of attorney unless it says it's not. That if it says it expires upon the incapacity of the principal, then it would not be a durable power of attorney. Does that answer your question?
Yeah, are there any good places we can access these forms so we can see what the choices are on them?
I don't know. I don't know if Ann has any that she would recommend, but I'm not really familiar with any of the online forms. I know that they're out there. And I promise you, it's not just lawyers wanting to take your money, that most lawyers are going to say, it's really important to sit down with somebody who understands this and can help explain it to you and can draft a power of attorney that's specific to your needs. So I there's nowhere I can suggest that.
I was thinking it was doing it ourselves. I was just thinking, I was like,
Oh, yeah. Sure.
Sure.
Sure. And maybe Ann would have some, I don't have any thoughts about that.
Durable power of attorney, Google.
Yeah.
Yeah.
Yeah. And there is, I didn't mention, there is another handout that you all have, which is just, this is put out by the state bar that has just like basic facts about guardians and conservators. And there's some information in there about powers of attorney. There's another great document that they put out that is if you have been appointed as a guardian or conservator, and it's sort of like a guide. And it is very, very helpful. We give it out to everyone when we have people being appointed. So there are certainly resources out there. It's just really important that you find something that is a credible source, as much as you can tell. And then obviously, really talking to a lawyer at some point if you can. Yeah.
Will y'all be going over
Yeah, I don't know. Executors, will you be talking about executors at all?
I can.
I will leave that to Ann. And yes.
Does every state have its own individual sets of laws? Are there any states that kind of have like reciprocal agreements?
Yeah, there are some uniform. So our Power of Attorney Act is a uniform Power of Attorney Act. So there are some uniform codes, but there are differences between states for certain things because a lot of the code sections reference other sections of the code. And so it's important that you don't assume, that your power of attorney is going to, take into account everything another state would require. However, most states are going to honor a power of attorney as long as it complies with a law of the state in which it was drafted and executed.
Is it a good idea to change that on your documentation if you move to another state because of the difference in laws and things?
I think I would, my suggestion in that situation would be to consult with a lawyer in a new state and see if there's anything that needs to be changed. But I don't think there's much risk there. I don't know, Ann maybe could weigh in on that too. But generally, states will honor, a document that is executed in accordance with the state in which it was executed. Anything else for me? Okay, well, I want to make sure Anne has plenty of time. I do want to put in a final plug. Today is the last day of Virginia's Adult Abuse Prevention Month. So we've had that all through May, and there have been some events trying to raise awareness. I'm going to put in a shameless plug here. The Department of Social Services in Floyd and really in all areas, all jurisdictions, we are always looking for individuals who would volunteer to be a guardian or conservator for someone who does not have someone to serve for them. And that sounds maybe hard to believe, but we come across it all the time with people. Sometimes it's that they have no family. Sometimes it's that they have family and their family is not willing to serve for whatever reason.
Or you don't want them to serve.
Right. Yeah, they wouldn't even qualify because they're, some of them are in jail or, whatever the situation. And so we really, really need folks. Right now we have 2 people, one who kind of does it a lot and one who does it here and there. But that is between Floyd and Montgomery. I mean, we really are in need. If you have an interest or someone who has an interest in serving as a guardian or conservator, we'd love to talk with you about that and all that would entail. So you can reach out to me or just the Department of Social Services in Floyd, and we will happily meet with you and answer any questions that you have. And be happy to hook you up with the other individuals who do that on a volunteer basis so that you can have an understanding about what that's about. But it's, I think it's maybe even more of a need than foster homes. But of course, that's always a big need too. But I appreciate your time today, and I'm excited to hear all that Ian has to share with us. So thank you.
All right, well, thank you for having me today. And I want you to think, I know you came here. Yes. Can they get closer? How about turn it up a little bit? And move up a little bit. How about that? Is that better? Okay, good. Thank you for saying something. So before I get started, in a presentation like this, there's a ton of things I could talk about. But there's a reason, and you mentioned executors, there's a reason you came here today. And Anne may have answered your questions, and if she did, that's great. But if there's something that you came here to learn, I want you to ask me, and I will try to, in my presentation, address that particular thing. Now, Anne said this at the beginning of her presentation, which is, I'm not giving you legal advice. So I don't want to hear, well, my father died, and then these 3 people, and then what do I do now? Okay, no. I want general questions, like what is the responsibility of an executor? What is the difference between a trustee or an executor? I've been named an agent under a power of attorney, and my mom died. Does the power continue or no? So if you have any questions like that, like a general question, raise your hand, and I'm going to take. I already know you want to talk about executors, and I can talk about that as opposed to maybe administrators versus trustees. I'll talk about that. Yes. Yeah. Stored. Okay. That's a great question. And how often that you revise them. Okay, that's a great question. Yes.
I have a question concerning agents who are on Medicaid,
Mm-hmm.
and the whole element of estate recovery, and what exactly, one of the specific questions I have is, what exactly does Medicaid or the state consider for estate recovery?
Are you talking about the agent being on Medicaid or the principal being on Medicaid?
Oh, the principal.
Okay.
Yes.
Okay, I can talk about state recovery. For Medicaid, and that would be for long-term care Medicaid typically, unless it's under a trust.
Yeah,
There's-
well, and then there's also, there are people who have the expanded Medicaid under Obamacare.
Oh yeah, and there's some, and I'm not as familiar with that, but they do have some of the state recovery there, and
Right.
I'm not as familiar with that. I work mostly with the long-term care. So the expanded Medicaid, I don't know the answer to that question. But I remember there's letters going out scaring the bejesus out of everybody, you know. Yes.
I don't know if this is something you cover, but I'm curious at what point a hospital or someone in the home could pay for bills and protection.
Yeah, that's more of a creditor-debtor issue. I can speak a little bit to that, but I don't deal with those kind of issues. So,
Trust, protect, doing.
I'll talk about that in terms of trust. Not a typical revocable trust, it would not. But I can talk about that versus asset protection. Okay, any other questions? I'm trying to hit on all these things. Yes, Janet?
A question that always comes up in everything, like when persons are looking at long-term care, there's a terminology, responsible party versus agent. And persons are thinking responsible party means personally, financially responsible.
Yeah, I mean, my practice, and I'll answer Janet's question straight up and then I'll go into my presentation, but if you're signing a contract as an agent for somebody else, okay, you're the power of attorney, you're the named power of attorney. If you are not named the power of attorney, and let's say it's your mom, and she went to the nursing home and she's incapacitated or is kind of confused, and the nursing home places the document in front of you and says, you're the daughter, will you sign this? You say no. And the reason you say no is because you don't have a power of attorney document and you don't want to be personally responsible, because if you sign something, right, you are personally responsible and you don't want to do that. So what you would sign is, and also I don't like the label responsible party. And anytime you get me to sign a contract, I am crossing out the words responsible party and I'm putting power of attorney, because I'm only committing to the assets that I have under my control. You know, I will use them for that person's benefit. I'm not going to take any of them. I'm not going to misuse them. But if I'm the power of attorney, I'm signing as agent under the power of attorney. So I would sign Ian Green, power of attorney for Sally Smith, or Sally Smith by power of attorney Ian Green. And then every place in that contract that it says responsible party, I cross it out and I put power of attorney. So other people handle it differently, but that's the way I would handle it. I don't like that language. In general, when you turn 18, and I'm looking around, I don't think there's anybody under 18 here. So that means everybody in this room should have a power of attorney, a medical directive, and some kind of estate plan with a will or a trust. Why? Because at 18, the law presumes that you've got capacity. So that means there's nobody else that can make decisions on your behalf, not even your spouse. So people think wrongly that, oh, well, everything's jointly titled or payable on debt to my spouse. So I'm okay. I don't need any of these documents. Okay. If you died, possibly that's true. But what's going to more likely happen? You're incapacitated, for a short period of time, even if not permanently. You're incapacitated and you want to sell the house. No power of attorney, no sale, because the house is in your name and his name. We need his signature for this closing. And you bring him from the nursing home to there, and the attorney at closing is going to say, he doesn't understand what he's signing. I can't have him sign this. And therefore, you're out of luck. No sale of that real estate unless you go to court and become the conservator so you can sell the property, correct? So everybody, so when my kids left for college, what did they have? Now they didn't do wills because I owned everything that they had. So not true now, they're 29 and 30 and they need to do their own stuff in their own states. But when they left for school, they did powers of attorney and medical powers of attorney. Why? Because I wanted to be able to talk to their doctors, and I also wanted to be able to manage any finances for them. I also wanted to be able to look at their grades, because even though we're paying for the college, we don't get to look at the grades unless we have a power of attorney of some kind. So,
Good enough.
yes. So, and some colleges now, universities, encourage parents to do that. In fact, my daughter went to High Point University, and we went down there, and they had like a little booth when you drove in at your required time, because they're like super uber organized, and they had this little it was raining that day, so they had this tent set up, and you stop there, and they had, and I don't like this because they had their own powers of attorney and stuff, but they had things there that the parents could they'd offer to the students to sign right there. They were over 18. Of course, you can't sign it unless you're 18, so 17-year-olds were out of business there. But 18 to give parents authority. So they were very pro parents. Now, there's other schools, I'm sure, that would not be so parent friendly, but it was very helpful. And that was really helpful because then I could pick up prescriptions for my kids. I could talk to my kids' doctor or make an appointment for them and all that. So everybody needs a power of attorney, I think, medical directive, and some kind of will or estate plan. So let's talk about powers of attorney, since that's where Anne was talking about in comparison to guardians and conservators. Powers of attorney are a document that a principal signs to give somebody else authority to act on their behalf. And as Anne said, it does not give them authority over that person. So when clients come in my office and they say, I gave my daughter power of attorney, now she's insisting I give her my keys and checkbook and she wants to take over everything. I said, well, now your daughter does not understand what a power of attorney is, because you're supposed to act on behalf of somebody. You don't get to control them. Now, there may have been good reasons the daughter was trying to do that. Maybe mom was driving and she was really scared, or maybe she's writing these checks to people all over the neighborhood and she doesn't even remember signing them. So I'm not faulting the daughter, but what I'm saying is that's not how a power of attorney typically works. You act on behalf of somebody. Now, one thing that you need to know is that powers of attorney and medical directives end when the person dies, as does, except for wrapping up some things, a conservator and guardian. It ends when the person dies. So you don't have continuing authority as power of attorney when the person has passed away. It ends at their death, okay? It allows you to help them during their lifetime. But the principal still retains authority to do all things for themselves, all right? And why do you need one? Because we don't know when we will become incapacitated. When we might become incapacitated, and when somebody might need to act on our behalf. So it's important to name that. When you name a power of attorney, we talked about co-agents a little bit. There's a couple ways to do that. One way I really don't like doing, some people do it, I don't like naming two people that have to act together. Good luck trying to get that honored at a bank, right? Good luck, right? Because you take it to Truist or wherever you bank and say, hey, here's my power of attorney, and I've named my son and my daughter, and they have to act together, they can't act separately. And they'll say, okay, find yourself another bank. Because how do they monitor that for every action? I mean, it's really difficult. What you can do, and what I often do, is do either of whom could act independently. Okay, now that's dangerous too, right? Because either one could go and write checks on your account. But then you have somebody who could watch the other one. So there's some accountability there. You can also require the power of attorney to do accountings to people. What I would suggest is that people are as transparent as possible. If an agent came to say, well, what are my responsibilities? Let people know what you're doing. Powers of attorney get in trouble when they're secretive and they're hiding and they are acting in their own interest rather than the principal's interest. So you can actually require accountings. The law requires an agent acting to account, right? So there's ways that you can force them under Virginia code to account for the last 5 years of their action, okay? Now, I have a friend who is a estate litigator, and he will tell you, good luck with that too, because there's so many ways to get around doing an accounting, because they'll say, well, Dad put my name on that account. I didn't use my power of attorney. Dad made me the beneficiary of all these accounts. I didn't use my power of attorney. So there's a lot of ways to be a bad actor if you're inclined to do so. And the law doesn't protect you from that. So I think the best you can do is make sure I like having co-agents, meaning either of whom could act, and then you always name a successor. And then ask, and you can put it in the document that they're required to give accounting. Some powers of attorney and some I've seen, I don't draft them this way, but some of them say, nobody gets an accounting of my stuff. My agent is directed to not give anybody an accounting. I think that's incredibly dangerous and also really, really self-serving. And I don't do litigation, so I don't do this anymore, but I was representing somebody who gave their son a power of attorney, and he wouldn't account to her as the principal because the power of attorney that his attorney drafted for her to sign said that there's no accountings need to be made. Well, that might be true to other people, but it's not true to the principal. He still has to do that. And so we had to go to court, but then the court was going to have her pay to make him do the accounting. I mean, so it's a mess. So let's go back to naming somebody as an agent. I'll have clients come in and they'll say, okay, I need to do some documents. And often people come in just because they need to do a will. They want to do an estate plan. They want to make sure that their assets go to whom they want, when they want, and they want to name who's in charge. So they come in and I'll say, okay, well, who will be your executor? And the executor is somebody who executes the will, which means implements the will as it's written and filed at the time of this person's death. Yes?
Yeah, I got a specific question on that. Say all the bills were accumulated by the person that died, there's a list, and they forgot one. And the executive takes care of that whole list, but the one is still pending. And then he thinks all the bills are paid and he disseminates the money out to relatives or whatever, and there's nothing left. And then that bill person comes in and says, yeah, you owe me money. Is the executive responsible for that, or is it just?
There's a lot of things. Okay, the question is if there is a bill left out when the estate is closed, who's responsible? And the answer is the typical lawyer answer, it depends. So like what kind of bill it was, it depends on if you know or should have known. That's why people do show causes. At the end of an estate, they say, hey, we're about to close the estate, and this will be after a year. About to close the estate. This is where the money's going to go. If you have an objection to that, please let me know, because if not, you're SOL. Okay, so, and that would offer some protection too. And so they have to have notice and all this. So creditors should be on notice. So once you file the will, typically the creditors have about a year to file their, but if they did not, they may be out. It depends on the type of creditor and whether you should have known about it and how quickly you dispersed. So if you're executor, beware. First of all, beware because you don't want to qualify an estate that's upside down, because that means there's more debts than there are assets. You may want to, because one of the priority payments would go to the administrator. That person will get paid. So the executor will get paid. But there's a statutory list that you must follow in terms of priority of payments. And if you don't follow it, you personally are responsible for those debts. So you got to be careful in distributing assets until you are confident you have all of them in. Because I got a client who qualified on the parents' estate. And they did a typical funeral, not a cremation. It's like $12,000. And so what did they do? They took the $12,000 thinking, well, that's her estate and that's an important bill, pay it. But the estate was upside down. The only priority for a funeral is $3,500. The rest of it is not prioritized. It drops down to the bottom with the rest of the general creditors. Problem. So just know that. And if I were going to do that, I might not even qualify, depending on the situation. So you would want to get legal advice before you did that. So,
Would that legal advice be paid
by the estate, yes, you can get legal advice. Typically, yes, because it's a cost of administration.
So administrative costs are priority.
Are one of the priorities, not the only priority, but yes, they are prioritized because they want somebody to actually do the work, right? And they're not going to make you do the work and then say, "Oh, too bad, you don't get paid." So that's how they do it. So when somebody comes in my office and they say, "Okay, I'm going to name a power of attorney. They'll say, okay, well, I said, well, who do you want to name? And they'll say, Barry. And I'll say, and why Barry? He's the oldest. And I was like, okay. Does Barry keep good records? Is he a good communicator? Will he be transparent about what he's doing? Can't say that about Barry. Okay, well, maybe Barry's not the best choice then for the power of attorney. Let's talk about somebody else, right? And then that happens a lot. We think the oldest boy or the oldest child or whatever is ordained to do that. And you have to kind of take that off of your brain. I know you want to treat everybody equally in your estate, but you want to get people who know what they're doing, or at least will find out what they need to do. You don't want to name somebody just because of their position, oldest boy, oldest girl, oldest child, whatever. So powers of attorney, you can make co-agents, but I always want to see an alternate. Reason being, and this doesn't happen as much now, but it used to happen all the time. I see people coming in with 20-year-old documents, and they have a power of attorney, right? Names their spouse. Wonderful. What happens when one spouse dies? Somebody's without an agent, right? There's no follow-up. There's no successor name. And I think they used to do that all the time. Maybe they executed 3 or 4, but different people. But so in ours, we'd always have an alternate name. Now, copies. Copies now under the Uniform Power of Attorney Act are as good as originals. So you can have copies of them. I would suggest not doing a copy of a will. It creates a lot of chaos and problems. Store them in a firebox, store them in a safe deposit box. Make sure your executor knows where they are and can get to them. They know where the safe deposit box key is, and either their names on the safe deposit box, or in that case, you could give them, a copy of the page where their name is executor, so the bank would let them in to retrieve that document if they had the key. Because banks are careful, as you probably know, they're not going to let just anybody in there. They have to have a reason to let you in. And so either you're an agent under a power of attorney, and you can show that. But if the person has died and the bank knows that, they're not going to let you do that. The only way they're going to get in there is if you've already qualified as executor, which of course is a problem if the will is in the safe deposit box. So if you have a copy of the page that says I'm the named executor and the original is in the safe deposit box, I got to get it, or I can't get you what you need to move on with this estate. And the reason copies of wills are problematic is because what happens if you destroy the will? If I give you your will, you signed it in my office and you took it home, and there's no way to find it when you pass away, the law presumes that you destroyed it, so you died intestate. If there's a copy floating out somewhere, let's say you did destroy it, but you gave Billy, who was, I don't know, you gave it to somebody and you destroyed it because you didn't like what you did in it, and somebody has a copy of it, they could go to court and try to prove that it's still a good will. So I think having lots of copies of wills around it is not necessarily helpful. Very helpful is to have medical directives, lots of copies of them. So you give it to your doctor in the hospital, and they don't really care about originals. They just want to see the document. Yes, ma'am.
So if you put together my will you then keep the original will with original?
Okay, the only originals that we would keep is if we would be named as the executor or the trustee. Otherwise, no, lots of liability in that. We don't keep documents for our clients unless the firm is named. And then, of course, we have to have them because we can't act without the originals. But typically, no. Now, I don't know what other attorneys do. I don't know. Do you know, Ann?
Yeah, I think that's the consistent practice, is that originals are not kept. Those go out with you when we're, have completed the documents, and we give that same advice with regard to copies. So I would agree with that.
Let's see. Spouse. Okay, good. I'm just looking over the, so powers of attorney for financial things, very important. And again, of course, I'm biased because I am an attorney, but I think it's really important to get them drafted for your specific needs. I can't tell you how many people will come in, especially in a long-term care consult, a long-term care situation where one or more of the parents are in a nursing home, and they're like, well, I'm power of attorney, I can do whatever I want? And the answer is no, you can't. You can do what the power of attorney document says you can do. You are the agent for that document. And if it doesn't give you gifting power, if it doesn't give you power to buy certain bonds that might be helpful for a long-term care situation, you can't do it. If it doesn't give you power to sell real estate, you know. So for instance, let's say some people come in and they have a disabled child who is independent, but on, let's say, Medicaid and maybe on Social Security disability income, not on SSI. So they come in and they have a disabled child, and they're concerned about protecting this child if they became disabled. So in their estate plan, we might do a special needs trust. But I also would put in the power of attorney the ability to gift the child or set up what's called a Medicaid payback trust for that child, so that if the parents needed long-term care, we could protect the assets for the disabled child. And we can make those, but I can't do gifts with a normal power of attorney. In the Uniform Power of Attorney Act, you have to have specific gifting power for that type of gift. So you'd want to put that in the document. But I'm not going to put that in every document. Most people don't have a disabled child, right? And in some cases, like when I meet with the family, they're like, yeah, she's disabled. Nope, we don't want anything to go to her, you know, because for whatever reasons that is, you know. So every situation is different, and you want to make sure that this power of attorney meets the needs that this particular family has. So enough said about that. Medical directives, really important. The most important part is the power of attorney for medical decisions, and that's only, unlike a power of attorney, which is good as soon as you sign it. The medical directive is a springing power, which means it springs to life when you are incapacitated. So for instance, if I have my medical power, which I do, meaning my husband, if I go to the hospital and he says, take out her spleen, here's the power of attorney, and I say, no, don't take it out. Unless the doctor says I'm incapacitated, they can't listen to him because I'm not incapacitated and you're not taking nothing out of me, right? So that's the difference between a regular power of attorney and a springing power of attorney. Some people draft durable financial power of attorneys as springing powers. I hate them and I don't do them. And the reason I don't do them is you take it to a bank, what's going to happen? If your financial durable power of attorney says, the only power this person has is when I'm incapacitated. When you take that to Truist to go use it, what's going to happen?
They're gonna require that you have proof that the person is incapacitated.
Exactly. You're going to have proof that that person is incapacitated every time you use it. I find them completely unhelpful, and because then you have to get the doctor, right, to say that. Will the doctor say that? Oh, it's my client. You know, I know he's doing bad, but you know, it's hard. It's hard. So I choose not to draft them that way. There are attorneys who will. So, maybe we could do a debate one day about which way you do. But I don't draft them that way.
How difficult is it to revoke a power of attorney?
Excellent question. Revoking a power of attorney. It's not difficult at all to revoke it. You say, I signed this power of attorney this day, I revoke it. And what I would do is probably record that revocation where you live so that nobody could sell your real estate using your power of attorney. I also would take it to every bank, send it to every life insurance, send it everywhere, because you don't know where that agent is. I would also personally serve that or have it served on the agent so that you know that they had noticed that they were not supposed to act anymore. If you haven't given it out, you just change it, just do a new one, and that would revoke the old one. But it's difficult unless the agent has notice, they could still act, so it's until they get notice is when, and then proving that they got notice is another hard thing. So you can revoke them, but it's hard.
Can you add a codicil to a power of attorney, or is it better to do an amendment?
The question is, do you do a codicil? That's to a will. I would not do an amendment to a power of attorney, just redo it. I don't know about.
I agree.
Yeah. I don't do that. Okay, so if someone's in a lot of trouble with long-term care, and I'll answer this, and they have huge hospital bills, hospitals can get very aggressive in terms of payment. But they also have charity care and, ways to pay bills for people who don't have it. I don't do creditor debtor law, so I don't know how often I don't think they come after your house if that's where you're living. So if you have another property, they could get a lien against it, perhaps. So if you're concerned about that, I would see like a bankruptcy attorney or an attorney who does creditor debtor law, because I just don't do that, and I don't want to misadvise you regarding that. Now, there are ways for long-term care costs, but also for other costs, for you to put assets into what's called an irrevocable trust. And there's a bunch of different kinds of them, and I won't go through that now. But if you put assets into an irrevocable trust, and generally you're not the trustee, you could be, but it's probably best that you're not, because people who end up being the trustee of an irrevocable trust often treat it like their own asset, and they mess up the whole reason to set it up. So you have a trusted person be the trustee of that. You might get income from that trust, but nothing else. Or maybe you don't get anything from that trust. You want to protect it just so you could live there. And if it's done, and it's not done with the intent of defrauding your creditors, typically that would be protected from your creditors going forward. And it also starts the 5-year look back for Medicaid long-term care. And we're not going to talk about that today, but that's another whole big issue.
What would be the definition of fraud in this case?
I'm sorry. Well, if you know,
Trust is designed to ensure.
okay, so defrauding a creditor is saying, I know you're out there, I know I owe you money, and you're not going to get this. I'm going to put it someplace you can't get it.
Which is what a trust does.
Right, but you could do it before you have any creditors. That's the point. You do it before you've gotten in trouble. Afterwards, it's a problem. I mean, I don't know you. So I wouldn't, like I'm asking people, why are we sending this trust out? Most of them is because I want to avoid long-term care costs. Okay, so it's a 5-year look back, and as long as you don't apply for benefits in 5 years, assets in that trust will be protected for long-term care as long as you follow the rules for the next 5 years. But if they've said, well, it's because, I don't have an umbrella policy and I got in a car accident, it was my fault, and they're coming after me, I'm not doing that trust. I'm not having anything to do with it.
So in an irrevocable trust, I'm assuming is exactly what it says it is. So once you set it up, you can never change it, like a will. If you set up a will and you decide, no, actually, I don't want it that way.
Okay, so technically, that's true. There are ways to get money out of it. I'll say that.
Okay.
But the idea is that you put it in there, like, was it set it and forget it? Ronco, whatever it is, set it and forget it. So, yes.
And in an irrevocable trust, you obviously have beneficiaries.
Yes, there's usually income beneficiaries who are often the people who set it up, and then principal beneficiaries who are often the children or the people that are trying to benefit from that.
So the kinds of things that you would put into an irrevocable trust would be real estate,
Yes.
investments,
Yes.
brokerage accounts,
Yes.
things like that.
Not IRAs, nothing like that, because IRAs are immediately taxable. You put them in an irrevocable trust, wow, depending on the amount, that's something you don't want to do. So yes. So estate recovery and Medicaid, and I'm going to exempt the expanded Medicaid because I just don't. I know enough to be dangerous, not enough to be helpful. So estate recovery primarily happens in my practice with long-term care Medicaid. So someone who's been on Medicaid, and when they die, the state sends out letters. Hey, you've been on Medicaid, and now your mom's dead, sorry she died. Does she have anything we can collect on? And typically, if it's just a single person, they have $2,000 and that's it. Now, there are sometimes, if they were in PACE or other programs, there might be a home. And if there is, that's at risk. And so you need to get good legal advice before you qualify on an estate like that. Because let's say they were getting PACE at home, the house is exempt because PACE is a program for all-inclusive care for the elderly. It's a program you can stay in your home and get Medicaid services, long-term care services. So let's say you're getting that and then you pass away at home. There's nothing, there's no liens against the house or anything, and the house was supposed to go to daughter, okay?
The will says house goes to daughter. She files the will. And there's other ways to do it, transfer on death deed maybe. But so she files the will. She makes the mistake of qualifying as executor. The next thing she should expect is a letter from Department of Medical Assistance Services saying, oh, executor, here is the amount that we paid for your mom's Medicaid. Please pay us because now they're a creditor. What I would advise in those situations is don't qualify, just leave it there. And now one of the creditors can go qualify. So they could qualify, but they often don't. And after a year or so, you could safely sell the house because the will transfers the house when you file it. The daughter owns the house, subject to be divested for creditors. And if she's the executor, they're going to divest her of that. But
So what do you mean by qualify as an
mean become the executor. Go to the courthouse, say, I'm going to be the executor, you get the executor's papers. You can file a will without doing anything else. Just put the will on record and walk away. And you have to file a list of heirs and things like that.
So if I'm named as an executor.
Yes.
And my father dies, I don't do anything. I don't take that.
Well, no, it's very specific to your situation. I was talking about a situation where someone's on Medicaid, long-term care, they have one daughter and they had a house. Every situation is different. I can't tell you what to do in your situation because I don't know what your dad's
Right,
estate
no,
is.
I get that. I'm just trying to get a sense of what you're meaning here. So after the death, the daughter doesn't do anything.
She would file the will if he had one, or file the list of heirs if he did not have one.
So they would do that. But
Yes.
But the act of qualifying for
Is different. You make an appointment with the clerk, and then you say, okay, what are the assets you anticipate will be in the estate? And you'll pay the tax, you'll pay, the fees to qualify, and you'll get a piece of paper saying, I'm the executor, which means then you can go all to the banks and round up the money. It gives you authority to act on behalf of the person who died. So you're the executor, you execute his will. And if there is no will and you're the administrator, meaning you qualify as the only daughter, let's say of a man who died intestate without a will, you would become the administrator of his estate. So, or not, depending on the situation. But before, and I emphasize before you qualify, get some decent legal advice from an attorney who does estate administration. Because there's times you want to qualify and there's times you do not want to qualify. Correct?
So
Yes.
Yes.
you're saying you don't want to qualify if the debt is going to be bigger than the asset.
That can be true. I mean, again, administrative fees might be worth it, but the hassle is the question, and unhappy beneficiaries who are not going to get anything, and unhappy creditors and if there's a ton of creditors, it might be just a nightmare to deal with. Let them fight it out.
So the administrator or the executor would not be responsible for those debts if they weren't married to the person, right?
Once a person qualifies as executor or administrator, whether you're married to the person or whether you're not, you are responsible for that person's estate, period. Once you qualify. If you're just named in the document and the document's filed and you didn't qualify, you're not responsible.
Oh,
In other words, the will says
yeah, that's broken.
the will says you're an executor, and when the person dies, you say to yourself, nah, I'm not gonna be the executor, you don't do anything.
You just put the will on record. You have an obligation, if you have the original will, to put it on record. Okay.
That's it.
And then you say, I'm not qualifying on this estate. I don't know what they have and I'm not going to dip in here. It's too much of a nightmare. So then the successor can do that. And then after, I think it's 60 days, creditors can come in and they can qualify if nobody has qualified. Yes. That is probate. If you have a will, you have a probate, period. Your will, you have probate. Yes.
A lot of people have life insurance.
Yes.
Think they're gonna use that to pay off their assets, but if they name children as the beneficiary, the children don't have to pay off the debts.
Thank you. So one thing you need to know about wills is that they control things that come into probate. That means that there's no beneficiary or co-owner or transfer on death designation on those assets. If there is, those assets go by contract, life insurance, transfer on death, payable on death, go to whoever was named, okay? The only things that comes into probate are things that are in the decedent's name, the person who died's name, that have none of that. So if that's only, and so that might be the house. And if the house has a mortgage on it and the life insurance went to these people, they don't have to use that for that. So the house is, underwater. And so you're gonna have to sell the house to pay off the mortgage. What's really messy is sometimes the beneficiaries are different than the will beneficiaries. And that gets really, so people do not understand that your will does not cover every asset that you have. It's really important. That's why I think attorneys who do this regularly, they write, okay, I'll say, what assets do you have? Okay, is that co-owned with anybody? Are there beneficiary designations? Because I've had clients come in and say, I want to do a will. And they told me, okay, my CDs have this, my life insurance has this, my IRA has this, blah, blah, blah. And then they wanted to give $10,000 to their church and all that. And I said, well, where's that money coming from? Oh, from the life insurance and my CDs. I said, no, you have beneficiary designations on all them. None of that money's coming into your estate, and none of your charitable beneficiaries are going to get paid because there's no money to pay them. Yes.
Your life insurance should be, beneficiary should be the estate.
Again, there isn't any should be's. There's only advice to you as in your situation. Because I think, because once if it comes into the estate, then it becomes, estate tax is the probate tax is very little. It's less than it's about 0.1%, so it's not expensive. But it would then be taxable. Now, probate taxable, not income taxable. If it goes directly to beneficiaries, life insurance, then there's no tax at all. It just goes to them. So it depends on the situation. I know there's not a blanket. I have a lot of clients who just leave that, and they have other resources that will be used to pay for debts of the estate. But you have to worry about that because you don't want to leave it, and I don't want to become executor with, their funeral expenses and their final expenses and their utility bills, and all I have is the house, and I have no money because they put beneficiary designations on everything. And you think, because what's going to happen is like the 4 kids, right? 3 of them are going to walk away with that money. And then you got good child, right? Good child's going to give her money in. So she gets less of a share than anybody else because she's the only one turning her money back in. So I want to make sure that good child, who's probably in charge of everything, has money to do her job, right? Yes.
Before you agree to become executive, how do you get this information? Do we know what you don't want to do?
See an estate attorney and just say, I've been named as executor. My dad just passed away. What am I looking at? And they're probably going to ask you, bring the list of assets that your father had or that you knew he had at his death. And then let's talk about it. And do you have an idea about his bills? Start forwarding his mail to you so you can start looking at the bills that are coming. Because it can be tricky. Sometimes you don't know. Sometimes you just don't know. All right, so talked about financial durable power of attorney. I think it's important to have everybody have one. Medical power of attorney is equally important. Why? Because somebody at some time is going to find you incapacitated, and you can name somebody who will make decisions for you. Again, don't choose oldest boy because he's the oldest. What about your daughter who's the nurse, who's the youngest? Maybe she would be the best person because she's going to be able to deal with the medical community better. Ask the questions, Oh, I'll put both my kids together. Do they get along? No, can't say that. Well, let's not put them both together. Maybe that's not the best idea. Yes?
So the medical power of attorney will just be written up and notarized, and that's it.
It doesn't, in Virginia, a medical power of attorney just needs 2 witnesses. It doesn't need to be notarized. If you go to advanced directive on the Virginia Advanced Directive, there's a statutory form that you could use if you wanted to. The hospitals mostly have them. Most hospices have a form of it called the 5 Wishes document. You could use that. You could use that. Yes. I would absolutely notarize it. 2 witnesses and a notary, absolutely. Now you can do a holographic will, which means one in your own handwriting. You write it all out and you sign it. You don't need it there, but Good luck. I would not recommend that either. I'm sorry? 2 witnesses and a notary. And you need a self-proving affidavit saying that we were all here at the same time. We watched each other sign this, and the notary notarizes that together. So it's not just 2 witnesses.
Isn't that the notary's responsibility? That's why.
Well, I would say it's the attorney's job to draft it so that there's 2 witnesses and the signature of the person doing the will. And then the next page is what's called the self-proving affidavit saying, here's the testator and the 2 witnesses, and we were all here at the same time. We're all over 18. Everybody was competent, and we all did this. And the notary sees them sign again. That's how we do it, and then notarizes it. And so we've never had troubles getting any of our wills probated. So that's what I would do. I don't know what other attorneys do. Is that
Exact same way.
okay? There you go. So 2 ands. You must know that means something.
We always made them initial on each page. too.
Yeah, I don't do that, but people can do that. Yeah, because then you can't slip a new page in there, right? Yeah. Let me just see if there's anything. Got that. Okay, so powers of attorney, financial powers of attorney, durable powers of attorney under the Uniform Powers of Attorney Act, powers of attorney for medical. I don't do them in the same document. Some attorneys do. It's like potato. It's whatever you want to do. I think sometimes the person who's best at finances is terrible at medical, and so I just like to separate them out. And also, the power of attorney we do now, because we reference the Uniform Power of Attorney Act, is like 7 or 8 pages. I don't need to have another 3 or 4 pages of medical stuff. And the other reason we do is because we also, besides a medical power of attorney, we also do an advance directive for people who want it, saying if I'm terminal, meaning in a persistent vegetative state or have aggressive terminal illness that the doctors say there's really nothing else we can do for you. And that is a longer term than hospice. This is a longer term than hospice. I would say if I'm in a terminal condition and my attending physician says that I do or do not want certain life-prolonging procedures, a ventilator, a CPR if your heart should stop, artificially given food or water, kidney dialysis, blood transfusions, and antibiotics. You can say, I want some of them, I want none of them. And then you can write that in your medical directive. I think that's personal. We don't need to have their banks have that information about you. So if you want to do that, I would write that. Let me caution you, because many people think that if they've done an advanced medical directive, either by downloading it or doing it with their attorneys, that is the same as a DNR. Please know, absolutely it is not. I've had clients come back to me and they said, that document you drafted for me, my husband, fell out at home, and when the rescue squad came, they started working on him. And I showed them that piece of paper and they just wouldn't look at it. And I said, yes, because it's not for the rescue squad. The only thing the rescue squad is going to look at is a DNR, do not resuscitate order, and attorneys do not do that. You're a doctor and you do that. Or if you're the medical power and you're doing it for somebody who's incapacitated, you could do one for somebody. So some people have them at nursing homes, but it's an orange piece of paper that's going to be on your refrigerator or on the door of your facility. Okay, and that tells them, don't resuscitate. Think about why that is. What can you imagine? Because you can craft your advanced medical directive however you want. I don't want CPR, but I do want to be on a respirator. What are these poor EMT guys coming to your house? Let's see. Okay. No, don't do that. She says no. They can't do that. They can look at your DNR. That's it. So recognize that if you want a DNR, and I don't think, like I've had clients call me and they, I want to do a DNR. It's like, I had a client who was, bless his heart, he's intellectually disabled. And he called me, he's 40 years old. He says, I've got to do a DNR. First of all, he's under guardianship, so I don't think he has authority to sign that document. But I said, why? Well, I just need one. And I said, well, I don't think you need one. You don't have a terminal illness. You might get unhappy sometimes, but that's not a reason to do a DNR. And I would hope doctors would have that conversation with somebody before they just sign a DNR. That you've got some health reasons that make it so that you would not want to be resuscitated. And I look around here and I think most people here would be want to be resuscitated because you're likely to recover, But anyway,
So just being old, it doesn't qualify.
that depends. Is being old qualified? Maybe with some doctors, I don't know. If I were the doctor, no. Because old is not old for everybody. More and more people are becoming centenarians, and our children or my children and their age group, there's going to be more and more of them who are going to live to 100 and not in poor health. And so I would say being old is not a criteria. I mean, I don't know. I'm not a doctor, so I don't sign them. Do you have anything? Yeah.
Advanced medical.
Yes.
The difference between that and just a plain one, is there one's more comprehensive than the other?
No. Okay, so the Virginia statutory form says advanced medical directive. It has two parts, the living will part of it, and then the healthcare power of attorney of it. So if someone doesn't want to do the living will part of it, I retitle it healthcare power of attorney. So that's how I would do it. I think it's just nomenclature, but they only act if the person's incapacitated, because otherwise you make your own medical decisions. Yes, Janet?
So I have two questions actually, if I'm listening to the person's question. One would be, and I, over the years, I've seen this happen, or attempts for it to happen, and maybe the Q&A can maybe give insight. If a person reaches a moment of incapacity to understand the document and be able to give informed consent or to make an informed decision, and person would attempt to obtain those have those documents constructed, what is your insight? Because we often see she's been diagnosed with dementia, she's been diagnosed with Alzheimer's, doesn't know the time of day, but they're attempting to go to an attorney to get these documents constructed.
I'll answer that and then I'll let Ian answer it. I think that's a huge gray area. I don't think there's an answer for each person. The way I would handle it would be, does the person know what we're asking them to do, and do they want to do it and understand what that would mean? Just a diagnosis of just dementia does not make you incapacitated. It does not. Because as you know, probably from experience yourself, people can live for decades with dementia. And just because they get that terrible diagnosis doesn't mean that they can't sign any documents. Now, there is a point along that path that they don't understand. And at that point, you're looking at going to court, guardian, and conservator. Anne, do you want to add to that?
Yeah, and there's case law even that people that have a guardian or conservator can sometimes, depending on the situation, execute certain documents, a will, whatever. So, like Ann said, it's really like case specific. And I think, in terms of coming into a lawyer's office, lawyers are under an ethical obligation to make sure that the person, to the best of their ability, that the person who's signing a document, like Ann said, understands what it is. And, we, at least, I go through when I was doing this, would go through sort of a battery of questions, make sure they understand. If there are concerns about dementia, then I'm thinking about the time of day they're coming in, like gathering information about, what's going on in their life. And so, hopefully, you're having ethical lawyers who are being careful about that. But I have seen some, I have had concerns over the years with certain documents based on the situation that I was aware of with an individual working with DSS. So unfortunately, sometimes you don't see that level of care.
No, I agree with that. And also, in terms of wills, I mean, now hopefully most guardianship orders should say, do you retain the right to vote, to drive, to carry firearms, which is generally not, but also to do a will. Because I had a client came in one time, and it actually was in Floyd County, they had a guardian, they had a conservator. And this was a long time ago. The rules are, I think, hopefully much better handled now. But she had capacity, and I took, because if she knew what she had, and she knew who her heirs at law would be, and where she wanted it, And, I went through everything and I took detailed notes because I knew that the people who got her under this conservatorship wanted those assets and she did not want them to have it. And so I was like, okay. So I took detailed notes about that and I did a will for her because the order did not prevent her from doing that. And like when she died 10 years later, of course, I get a call, right, from the proponent of the will, and then also from the people trying to say she didn't have capacity. Because, unfortunately, when they tried to file the will, they said, oh, she was under guardianship, she couldn't do it. That's not the law. It's not the law. And I said, you tell them it's not the law. They need to take the will. And they did. And then they called me and I said, you don't want to call me, the people who are coming against her, you don't want to call me because if you do, you'll see all my detailed notes that she had absolute capacity. I did that specifically to make sure that she knew what she was doing and I knew that she knew. And there's nothing in the guardianship order that prevented it. And the case, after like 3 years, finally went away. But it was
Good
a shame.
job.
Well, yeah, just it's crazy. So,
So the other
Yeah.
question that I have, when we're talking about advanced medical directives, we often see some barriers that are imposed by the mental health field, the mental health facilities. Could both of you address and I call it the mental health, either the mental health addendum to an advanced directive or the combined?
yeah, I see them like people attorneys who, I don't know, but they're always in there. But they shouldn't be in there because they're supposed to be mandated by a doctor for certain. So what you're referring to is, I want to say they call it a Ulysses clause or something, but it's a clause that says, if I'm off my meds, you can force me to take these meds, and they have to get a doctor's order on what the meds are. Or if I am acting crazy and you're about to have me under an involuntary commitment order, if the facility that you want to take me to will take me, you can involuntarily commit me for 10 days. Again, you got to get a doctor to say that that's appropriate and sign that. I've only had one client in all the clients I've served be willing to do that. I think the main problem is it came up because NAMI wanted it there to protect folks who recognized that they had issues, and if they got off their meds, it'd be better to have someone have authority to get them in line before they lose everything again, but most people with mental illness do not want to sign up. I don't know about your.
Well, and I think not only that, but I think part of the problem too is that it sounds good, perhaps, if somebody has that awareness, but when that comes to pass, when that person is off their meds, and actually that practically how you make that happen. I mean, we deal with stuff like this all the time. It becomes a nightmare. It's really not that helpful when actually push comes to shove and the person's off their meds and you're normally going to be ending up either before a court or more likely with some sort of temporary
TDO.
A TDO and a special justice. I mean, if there is someone, for example, who is, needs to be in the ER, they're trying to leave, there's a special justice I'm a special justice, I will get a call from the ER saying, I need a medical hold on this person, here's what's going on. So there are ways that the law has to address that without trying to get that into, a document like that. And I think it's probably more effective, under the circumstances.
Yeah, does that answer your question? Okay. So powers of attorney for financial, powers of attorney for medical, with or without a living will, and then wills. And wills are basically saying, now, this is for things that come through the will. Remember, lots of things go by beneficiary designations. Sometimes that works, and sometimes it's a disaster, right? Because sometimes people don't die in the right order. And wills or trusts can handle all that. And beneficiary designations have a more difficult time doing that. You don't want to name minors. You don't want to name people who have special needs. There's a lot of people you do not want to name as beneficiaries of, like I've had clients come in and say, yeah, my grandchildren are all named in my IRS. And I was like, how old are your grandchildren? 7, 9, I'm like, please, let's fix this, you know, because when they die, someone's going to have to become their, have to become their guardian of the estate for those assets to manage them. They have to go to court for that. You know, it's a mess, and you don't want to do that. You don't want to leave anybody who's legally incapacitated minors. And also, I'd argue, many 18-year-olds and 19-year-olds, maybe they don't need to get their money. Maybe it needs to be in trust, have somebody else manage it for them until they grow up some, right? I'd argue that now there's a delayed adolescence that, you know, when I was growing up, teenagers were different. I'd say my kids are growing up, the people who were doing what I was doing in high school are now doing it in their late 20s. And so, you know, I think people are maturing later. Not everybody, thankfully, but enough that it's a concern that you may not want people under 25 just getting a big lump sum. And good luck to you, because it'll be gone. And I've seen that happen, unfortunately, just immaturity. They just don't know. So, all right. And I think we are just about out of time. So I'm going to stop here. So for some questions, if you had questions about anything.
So if you're writing your will, let's say I've already got beneficiaries, I've already got transfer on death on my titles, do those need to be listed in the will as well?
No, because they have nothing to do with your will.
They're already just going right to that person.
Yeah. The only thing your will is going to handle are things that are not only in your name at the time of your death.
Ownership, not in there.
Not in there. It would be maybe your house, maybe a car, maybe, you know, and Iris should have beneficiaries, so they shouldn't fall in there. You don't want Iris to go through your will anyway, because it'd be very expensive to do that. Any other? Yes. Yes.
When you talked about the conservator, is
Yes.
appointed by the court
Yes.
because of incapacity.
Yes.
But then you was telling about how someone came in that had a conservator, that you was able to write a will for that.
Yep.
If they've already been determined incapacitated.
They're incapacitated. Okay. So the word incapacitated.
Not necessarily.
No. It is mentally, but incapacity is really a terrible term because it's incapacitated for what purpose? Okay. The court found her incapacitated. I would argue that should never have happened in this particular situation, but it did happen. Okay. But you're incapacitated maybe with running your money, right? But she still knew who her heirs at law were. She still knew what she had. She still knew who she was and what she was doing. She had made all the testamentary capacity criteria. So she was incapacitated for that purpose. But unless the guardianship order says she does not have the ability to do a will, she has the ability to do a will.
I guess I would question what was the purpose of a conservator.
In my point exactly. It was to get control of her assets is what it was.
Okay.
Well, and I will say too, I mean, I think there are certain circumstances where, you know, we have somebody who, you know, you go in and talk with them, they kind of keep repeating the same things. They're going back to, you know, they think we had a gentleman who thought he was at a dorm when he was at his assisted living, and this is a great school. You should send your kids here. You know, I just was in a lecture, but know who his children were, and is not capable of managing money. Knows that he has had some money. You know, knows that he has, you know, was living in a house and now he's living in this dorm, and so you know that might be an extreme example,
Right.
but there are certain cases where you know enough to be able to say who you want to have, you know.
Also, they could be manipulated.
belongings.
People sometimes get under a conservatorship because they've been taken advantage of, and it's for their own protection. And so that would be another case. The person might have capacity, but and I will tell you, and I hate to tell you this, and tell me if I'm wrong, Ann, but the person most likely to take advantage of you is your family.
Yeah.
You know, powers of attorney are most often misused by family members. Hate to say it, makes me sick.
Sometimes your children are number one.
Yeah, I mean, it just is. It's just a terribly sad thing, and it's really hard for police or anybody to help, because what happens? Oh, I don't want him to go to jail. I won't report it. And I've learned now, you know, after practicing for 35 years, if you aren't willing to help me help you, I can't help you. you know, because people can come to me and say, oh, my daughter did this or this. Are you going to report it? Oh, no, I don't want to get her in trouble. Okay. I
All
mean,
the time.
it happens all the time. I'm sorry, because then you're choosing to participate in this manipulation, and I can't help you. There's nothing I can do if you won't stand up for yourself. So, yeah, and the police can't either, and they won't get involved, and you won't get a civil attorney involved either, because if they're not willing to say she stole from me, or she did this, or she misused that, or you know, then you're going nowhere with that. So, all right, any other questions or? All right, well, thank you for coming today, and